Well, welcome, Facebook Live friends. I appreciate you joining us once again for our weekly stream of the Bradford Botes Facebook Live. Those of you that have been with us know that we've been doing this since the COVID pandemic caused all of us to spend more time in front of our computers rather than out and about. We know that there's a lot of concern out there, a lot of people that have bills piling up, perhaps without a paycheck. Some of you have been getting unemployment checks and know that at least the federal unemployment checks are going to be stopping at the end of July. So people are starting to get a little bit nervous. And we want to be able to provide information to you about what you can do to address debt and deal with those payments that are racking up and help you come up with a plan. It's very important right now that you be proactive. So many people are shut in and they're just letting anxiety get to them. They're becoming depressed, and my best advice to you is don't let all of this get to you. We're going to get through this. We're going to get through it together. Our country's certainly been through a lot worse problems in the past, and we're going to get through this too, but we're going to get through it together, and we want to help. The Bradford Botes law offices are located throughout Alabama, Mississippi, and in the Knoxville area in Tennessee. And we've been helping people with financial problems for over 30 years. What we encourage you to do right now at all of our offices during the COVID pandemic, we are offering an absolutely free initial consultation with an experienced attorney, an attorney experienced in dealing with financial issues. And for your safety, for your comfort, we're offering these consultations. If you want to meet in person, we can do that. But if you're more comfortable, we can do it by video, just like this, by telephone. We'll do it from the comfort of your own home or office. And there's no obligation. We, again, just encourage you to reach out, seek advice, and find answers from an experienced attorney, somebody that you can trust, rather than relying on things you may see online and hear from your friend's cousin. Today's episode, I'm very honored, very thankful to have my good friend, John Steinkamp. John has a practice similar to mine. John is located in the Indianapolis area in Indiana, where he represents people that have financial problems. John has a great bankruptcy practice in the Indianapolis area, helps people deal with creditors, with how to deal with financial problems. But the topic of our show today, and the reason I've asked John to join us, is we want to talk about how you can deal with those abusive debt collectors that are out there. We all know who they are. They're the people that call at all hours, the day and night, people that are disrespectful, people that continue to fill your mailbox with letters. Well, John's an authority on the Fair Debt Collection Practices Act. We often refer to it as the FDCPA. So in addition to being an excellent bankruptcy attorney in the Indianapolis area, John is also an authority on dealing with abusive debt collectors. John, it is really an honor to have you with me today. Thanks for joining me.
Well, you're very kind. Thank you for having me. I appreciate it.
I've got to know John over the years. John is a father, two young girls. He's married to, and I'm drawing a blank now, your wife's first name?
My wife's name is Jean, and she is a veterinarian here in the Indianapolis area. So at any given time, we have lots of animals at our house.
I knew that. I knew she was a veterinarian, and it just sounds like you have a great family, John, and we're both blessed in that way, and that's really what this is all about. So, John, you and I have both represented people with money problems for a long time. and we know that options exist. People should not panic right now. People should not be distressed. People should be seeking solutions to the problems that they face, that the problems that have been really thrust upon them by this pandemic right now. You and I both know from having counseled hundreds, thousands of people over the years that the stereotypical perception of a bankrupt, of somebody that seeks bankruptcy protection, is really not accurate. The vast majority of people that come into my offices are good, honest, hardworking people that have had something bad happen to them. Do you see the same in your office, John?
I do, and I agree wholeheartedly with your statement. I tell people that probably 1 out of 20, 1 out of 30 is what you just referenced as a stereotypical person who's filing bankruptcy. Maybe they've been foolish with their credit cards or whatever. But the vast majority of all other people that are seeking bankruptcy protection are people who have had life throw them a curveball. They've gone through a divorce, unfortunately. They've had a heart attack that they didn't expect to have happen, or any other health issue. I can't tell you how often I talk to senior citizens, and I ask them, so what do you spend on prescription medical expenses every month? And they're like, well, do you want to know the ones I can afford or the ones I've been prescribed? So in other words, they don't have enough money to pay for the drugs that their doctor has told them they need to take to live. So it is unfortunate what a lot of our clients go through. And, as the attorney, I'm often just amazed at the strength of these people, the strength to keep going and the strength to get up every day despite the horrible curveballs that life is thrown at them.
Yeah, it truly is. It's amazing, and it's inspiring to know that there are good, hardworking people. And again, the vast majority of the people we see are people that just have had a curveball thrown at them. In the past, it may have been a sickness, it may have been a job loss, an injury. Well, now a lot of people are facing COVID. They're facing loss of jobs. They're facing mortgage payments that are piling up that they're unable to pay, perhaps car payments, credit card bills. I emphasize, pardon me, John?
Loans have been deferred, and the pipers are going to come once that deferment is up, and the pipers want to get paid. And so this isn't just senior citizens like I referenced. This is going to be a lot of younger people, a lot of millennials who are now happy they don't have to deal with student loans, but the student loan monster is coming back.
I again encourage people, our phone number and our firm's website address is at the bottom of our screen. I encourage people in Alabama and Mississippi and in Knoxville, in the surrounding area in Tennessee, to reach out to us for an initial consultation. We'll also put John's phone number and website address up on the screen if you're in the Indianapolis area and you need assistance. John, are you also offering free initial consultations at this time?
Of course. And we offer initial consultations. I'm happy to do phone consultations, in-person consultations. Of course, we socially distance. I've modified my office for that. And then we can do Zoom conferences as well. I'm happy to do them certain after hours or Saturdays, whatever it takes.
Well, at the beginning of this episode, I mentioned that you have particular expertise in dealing with abusive debt collectors. Now, not all debt collectors are bad, but there certainly are some abusive debt collectors, and it's important for people to know their rights. So just to outline for our viewers the topics we're going to cover today, there are rules. The United States laws provide specific rules that govern when and how debt collectors can contact you. It's known as the Fair Debt Collection Practices Act. And John and I, and those of us that practice law, most of us refer to it as the FDCPA. It's a wonderful law. It has great teeth, really gives us great resources to help people that are the victims of abusive debt collectors. We want you to know what your rights are and when they've been violated, what to do if you're being harassed by a debt collector, what the resources are out there for getting help. And then after we go through that, John, I want to take some questions from our viewers, and I encourage our viewers, I see a number of you online now, feel free to post your questions, and we'll try to get them addressed before the end of this Facebook Live episode. If not, we'll certainly follow up afterwards with you. So, John, are you ready?
I am.
All right. So, the official rules that we have that govern debt collectors are found, as I said, under the Fair Debt Collection Practices Act. So give me a little bit of a description and explanation of what the Fair Debt Collection Practices Act is and what it provides.
So it provides a way for consumers to protect themselves from abusive debt collectors. And I agree with your statement that not all debt collectors are bad or evil. Many of them comply with the law, and they have their role in society to fulfill. However, there are plenty out there that are not so scrupulous, and sometimes they cross the lines. And the FDCPA is a fantastic statute that gives consumers certain protections from those abuses. For example, debt collector can't call you before 8 a.m. and they certainly can't call in the middle of the night. They can't call after 9 p.m. And this is at 8 a.m. and 9 p.m. where the consumer is, not where the debt collector is. So if your phone is ringing before 8 a.m. or it's ringing at 2 o'clock in the morning, that's something that I think consumers ought to reach out to an attorney to talk about. Because that is certainly one of those things that's bad. That does not comply with the law. Also, people need to know that debt collectors cannot call you at work. On a regular basis, I have clients that come through my doors and they're like, hey, I've got a debt collector calling me at my office. Leave me voicemail messages on my office phone, and that is illegal. If you get a call, if a consumer gets a call from a debt collector at work, they simply need to say, do not call me here. I cannot take private calls or personal calls at my place of employment. And then that's it. The debt collector cannot call there ever again. Likewise, a consumer can retain counsel and say, hey, Bradford Botes is my attorney, call them. And that's an easy way to get the debt collector off your back if you are getting calls from the debt collector. But it's important to note that they have to identify an attorney. They can't just say, oh, I've got counsel. They've got to say, my counsel is Brad Botes or Bond Botes, or whomever. But they can't just say, well, I have an attorney for this. That's not going to work. But once the attorney is identified, the only thing the debt collector can do after that is say, okay, give me the attorney's name and number, and then I'll call them. So in my practice, and I'm sure you do this as well, Brad, is I give my clients several business cards after they retain me, and I tell them keep one on you at all times. And if a debt collector calls you, you're going to pick up and say, grab my card and say, hey, here's my attorney's name. Here's how you spell it, because no one spells Steinkamp correctly. And contact me. And you know what? That works. I've had a number of clients say that gets them off their backs, because most debt collectors will comply and will say, okay, fine, I'll call Steinkamp and I'll harass Steinkamp. But once in a while, we have them where they just keep calling. And then those will often turn into cases.
So what types of, I think this is important, the Fair Debt Collection Practices Act doesn't apply to all debts. It only applies to consumer debts. So if you're running a business, there may be some other relief available, but the Fair Debt Collection Practices Act is designed to protect consumers with consumer type debts. Important things, though, for consumers to know. Number one, the FDCPA, people ask, will I have to pay attorney's fees for you to represent me under the FDCPA? FDCPA has some certain provisions. Perhaps you can address those for us, John.
Right. The FDCPA has a fee shifting provision, which is a fancy phrase meaning if you prevail against the debt collector, the debt collector has to pay your attorney's fees. And that is great. On a regular basis, I have clients that will ask, that's great, I've got a lawsuit, but I don't have any money to pay you. I'm like, it doesn't matter. I'll make the debt collector pay my attorney's fees. And my clients tend to really enjoy that. And it's interesting that my clients are often so grateful that I've gotten the debt collector off the back and we've prevailed against the debt collector, that the client will ask, okay, I'm going to get up to $1,000 from this lawsuit, because the FDCPA says if you prevail against a debt collector, you can recover up to $1,000 just in what are called statutory damages. Think of it as like a civil penalty for violating this law. So, but the client will say, well, how much of that $1,000 are you going to get? I said, no, that's all your money. You keep that. That's your money. Do with whatever. I'm going to make the debt collector pay me my attorney's fees. And then they're grateful again. They're like, oh, that's great. You got them off my back and I don't have to pay you. So that's a part of the FDCPA that is really beneficial to consumers.
And John, I don't know about you, but after having practiced bankruptcy law for a number of years, there is nothing to me that feels better than when somebody comes into my office, they've been beaten up by debt collectors, that they're really in a bad place, and I'm able to hand them $1,000 check from one of the collectors that's been bothering them. It's just really a good feeling. Somebody comes to me seeking bankruptcy protection, and because these collectors have been so tough on them, not only can I get them debt relief, but I can get them some money back. And where I really encourage my clients is many of them have received letters from collectors. We ask them to bring those letters to us. So often we find violations of the law, violations of the Fair Debt Collection Practices Act in those letters. Let us review those letters for you. Keep good records. Keep the envelope, all the information you can, but get them to us so we can review them for you. I assume you do the same type thing in your office.
I do. I tell my clients, save all bills, bank statements, paycheck stubs, save all financial documents, because I'm going to need them. And sometimes I have clients who say, well, do you want me to weed out the duplicates? And I say, no. What's a duplicate to you is not a duplicate to me. These bills change over time, and those changes don't mean anything to the public, but they mean a lot to me. And so I tell clients, save everything. If clients say I've got a mountain of bills at home, I've got a box that says bills that I will give to them. And I tell them, as the bills come in, just dump them in there. You don't even have to open the envelopes, just save them all, and we'll take a look at it. But a great story about getting clients money. I had a client about 2 years ago come into my office, and he had with him this mountain of bills, and I went, and then he had been harassed by a couple of debt collectors over the phone, and we talked about one of those phone calls, and I told him, well, you certainly have a lawsuit against that debt collector because of the things that they said to you. And in his stack of bills, he had a class action notice, and that class action notice was a case that had been brought by our good friend Dave Phillips and myself, and it's where this client was going to recover money. And I was able to tell the client, I was like, before you ever stepped into my office, I was already trying to put money in your pocket.
Yeah.
So
that's great. That's great. Yeah. You and I both do some of that class action work where we're able to get do benefit for a whole lot of people that have been victimized by abusive debt collectors. There are a lot of important tools under the statute. One of the issues we see a lot are collectors that are trying to collect on debt that we call time barred. Can you explain what time barred debt is for us?
Sure. A time barred debt is a debt that is beyond the statute of limitations. Each state in the union has its own set of laws regarding the statute of limitations as to when a lawsuit can be filed on a type of claim, be it a personal injury claim or be it a contract claim. Most debts arise out of contracts. In Indiana, the statute of limitations for a contract is 6 years. And so when clients bring in the bills like you've described, my staff and I scour those bills to try to find whether or not they're beyond the statute of limitations. In my jurisdiction, if they're beyond the statute of limitations, the debt collector is required to add a disclaimer to the notice or disclosure stating that this debt is beyond the statute of limitations. And if they do not, then almost certainly a lawsuit will be filed against that debt collector, and often these are class action lawsuits. Very important to know, things to know for people who are listening, that if you get a call from a debt collector and that debt is really, really old, you can restart that statute of limitations by making a partial payment. So my advice is, if you believe this debt is way beyond the statute of limitations, super duper old, don't make a partial payment on it. Ask the debt collector to send you verification of the debt so you can take a look at it, see just how old it is. If you still have questions, consult an attorney like Brad Botes or myself, and we'll be able to tell you whether or not this is a debt that you should pay, or whether or not it's a debt that can be included in bankruptcy, or is it debt that's going to become a basis of a lawsuit against that debt collector.
That's such an excellent point, John. So many of the folks that we counsel with think that as long as they're making some kind of small minimum payment, that they're safe, and they scrape together pennies. But what they're really doing is they're turning a debt that was barred, that was too old to collect on, into a collectible debt. If the statute of limitations has run, then there's no obligation for you to pay that debt under the law. I think it's important for consumers, for people that are watching right now, to understand that the term debt collector in a lot of cases really is a misnomer, because what we're seeing more and more of are debt buyers. The way the model works is that, and there are just a small number of large players, companies out there that buy large portfolios of debt that have been written off by MasterCard or Citibank or one of the big credit card companies. And all they really buy sometimes is a spreadsheet with a name and an amount and an address, and they start collecting on these debts with very little information. Often the statute of limitations has run. Has that been your experience also, John?
Yes, it's. I think the industry has changed a little bit over time and it's gotten better, but it is almost always the big debt buyers that we see trying to collect on debt that's 11, 12 years old, and you're absolutely right. They don't buy the actual contract; they buy just some tidbits of information, and then that's where problems occur, because maybe they don't have all the information about the consumer, and maybe they're calling the wrong Michelle Smith, or they're sending bills to the wrong Michelle Smith. And then when the consumer, who under the FDCPA has the right to dispute these debts and to get verification of the debt to ensure that it really is that their debt, these debt buyers are not able to produce the documentation necessary to comply with the FDCPA to prove to the innocent consumer, yeah, this is your debt. On a regular basis, like I said, we have people who are like, I don't know what this debt is. It's not mine. I've got a lawsuit right now. My client subscribed to a credit monitoring service, got a ding that there is an old Sprint account that went on his Experian credit report. So he calls the debt collector immediately and says, hey, this isn't my debt. This is my ex-wife's debt. I've been married to her in 5 or 6 years. And he's like, send me documentation to show that this is my debt, because the debt collector argued with him a little bit. And you know what? They never ever sent verification. And so we filed suit because he has a right to that information and documentation. The case is not settled yet, so we'll see where it goes.
Now, I also encourage people, often it's not just a letter or a phone call they receive from these debt buyers, but it's a lawsuit. And with those lawsuits, consumers assume that they have no rights, that they're going to be rolled over by some big law firm in court if they show up. But I encourage people If you are sued by one of these debt buyers, answer the complaint, do it timely, or get an attorney to help you, because very, very often, again, this debt buyer's just bought some information off of a spreadsheet and they're not prepared to prove that you owe the money. But if you ignore the lawsuit and there's a default judgment taken against you, you're in a lot worse shape. So, John, I want to just take a short break here, and I want to remind folks again why we're here. At Bradford Botes, we've been helping people with money problems for over 30 years now. During the COVID pandemic, we are offering absolutely free consultations with an experienced attorney in your state. We practice throughout Alabama, Mississippi, and we're in the Knoxville area in Tennessee. If you're not comfortable right now actually coming into one of our offices, we'll do that free initial consultation by video or by phone from the comfort, safety of your own home, your own office. We'll meet just like John and I are talking now by video, if that works best for you. We want to help you. Be proactive, reach out and get help. There's no obligation when you call one of our offices. You're just getting information, how you can protect yourself, how you can be ready when we get back to as much normalcy as possible. But we want you to save your home. We want you to save your car. We want to make sure you're getting your full paycheck once you're back to work, if you've been off of work. There are solutions out there. Trust an experienced attorney. My firm's phone number and our website, it will be on the screen for you. Again, please feel free to reach out at any time. We have call representatives available to schedule an appointment with you when you call in, or if you're not comfortable calling right now, go to our website. We have a lot of information on our website. We've blogged on just about every issue out there. And you can fill out a form there requesting an initial consultation. John Steinkamp helps people with money problems in the Indianapolis area in Indiana. John is an excellent consumer bankruptcy attorney, also helps people that are being victimized by abusive debt collectors. He can do a great job for you, and John's phone number and website address are both available on the screen. So reach out. If you're in Alabama, Mississippi, Tennessee, reach out to Bradford Botes. If you're in Indianapolis or the surrounding area, reach out to John Steinkamp. We'll be glad to help you, but free advice is available to you right now. Don't just depend on something that you heard from a friend or you may have seen in a social media post. Reach out to one of us and let us help you.
I build on what you're saying.
Sure, John.
There are a lot of misperceptions out there, a lot of misinformation that you might find on the internet. So I can't, and every day I talk to a new client who says some sort of weird stuff that they've heard through the grapevine. Don't believe it. Call an attorney, get the real facts, get the real advice, and put yourself at ease.
John, when we were talking before we went live, you talked about a particular type of collector that can victimize certain people. You and I are both familiar with these scam type collectors that try to take advantage of people. And these people are even worse than the abusive collectors we discussed earlier. Tell us about those type calls and how people should treat them.
Sure. Probably once a week or so, I get a call. It's almost always a little old lady or someone else who is just simply not very sophisticated with how the law works. And they've taken out, and it's almost always a payday loan or a cash advance of some type. And they can't make the payment on this short-term loan. And so the debt collector associated with that cash advance place or that payday loan place will start calling these people, and they'll just say horrific things to them. And it's just awful. It's heartbreaking. They'll tell them, look, you pay me now or the sheriff is going to come and arrest you. And if you pay me now, I can call them. I've got my other phone here. I can call them up, and I'll call off the cops who are coming to your door right now.
Mm.
Or they'll call them up and they'll say, well, you're going to get served with papers, and they always use legal terms in somewhat appropriate ways. A non-attorney would totally be intimidated by it. An attorney would be like, no, that's not right. But these unscrupulous debt collectors are often based out of the country. They're often based in Indian reservations, so they're almost always judgment proof. We could sue them, but it's not going to do any good because they've got no assets, they've got no insurance, and they're just awful. I hate them. What I typically tell clients is, first, don't panic. The police do not enforce debts. There's no such thing as debtor's prison. So don't worry about these people. They're lying to you. And then I tell them, look, give them my name and number. If that doesn't work, then tell them you're going to report them to the FTC, the Federal Trade Commission, or the Attorney General's office. Or just start asking them for their information. Where are you located? What's your name? Where's your office located? So that when we sue you, we know where to send the paperwork. And so this is the one part of my job I really dislike, because I feel like there's not a lot I can do, since these scam artists are not in the United States often, or even if they were, they wouldn't be worthwhile suing because they have nothing. They're scams. So I would encourage everyone to be careful about that. And if I were king for the day, I'd probably get rid of all payday loan places and cash advance places. I get that sometimes we need money, and life happens. Life throws you curveballs, and maybe you don't have family to turn to, and you have to turn to one of these short-term loan places. But I guess if they do survive, or they are out there, they need to be more highly regulated. They really do.
Absolutely. Absolutely. You and I both see the destruction that those type of people can do. So again, this is our 10th episode now of Facebook Live at Bradford Botes, and we'll continue to do them every Wednesday at 1:00 p.m. Central Standard Time. We know that people are worried about financial issues, and we want to address your problems. We've used these Facebook Live episodes to address a number of different topics. Last week, John, we had a very interesting guest. We had an author by the name of Adam Webster. Adam went through some struggles, went through a bankruptcy, and then he wrote a book about it, and how he took advantage of the fresh start, emerged, started his financial future from scratch. He's now a very successful real estate investor. It was good for me to show what life is like after bankruptcy to people that may be having financial problems right now, and to let people know there's hope out there, and federal bankruptcy laws exist for a reason. They exist to give an honest debtor a fresh start. But today, this episode, we have my friend John Steinkamp, Indianapolis, Indiana bankruptcy and Fair Debt Collection Practices Act attorney. John's information is on the screen. John, so if somebody thinks that they're being taken advantage of by a debt collector, if debt collector is doing something that's improper, what's the first thing an individual should do?
I think they should take notes of the conversation, jot down who they spoke to, what debt they were talking about, and notes about the content of the conversation. And then they should contact an attorney such as you or myself. Things not to do would be, don't threaten the debt collector. So, quick story. One of my first cases, my client, who's a middle-aged male, says that this debt collector threatened him, said horrible things to him, and everything like that. So I, after talking to him, I said, well, I think you have a case. Now, keep in mind, again, I was very green when this happened. This is one of my first FDCPA cases. So we file a suit. The debt collector gets an attorney who promptly sends me the telephone conversation, because all these conversations are recorded. And oh my gosh. So what my client didn't tell me was that he threatened the debt collector. It was something to the effect of, I've been to the big house for aggravated assault. I have no problem going back. And I was like, oh no. And so of course I had to dismiss that case. So don't fight fire with fire. Jot down notes and move on, and talk to an attorney who can steer you in the right direction.
We in our offices, we of course encourage people to do what you described earlier, and that's keep copies of all the bills, the collection letters you get, the envelopes that they come in, so that we can review them for you. But we also provide our clients with what we call an evidence log. It's just a little sheet where we encourage people to keep track of contacts they have with debt collectors. Again, if you've retained one of our offices and we're representing you, and you advise a debt collector of that, they're supposed to stop calling you. They're supposed to contact us. And if they continue to call you, they're potentially violating the Fair Debt Collection Practices Act. Or if we file a bankruptcy for you, they may be violating an order of the bankruptcy court. So it's very important to keep good notes, good records of any contact you have with a debt collector. If they call you, try to make note of the time, the date, the number the call's coming from, who you spoke to, what they said, as much detail as you can, so that we can use it to help you protect your rights under the Fair Debt Collection Practices Act. John,
excuse me 1 second. Let me build on something you just mentioned. So if your bankruptcy case has been filed, and let's say it was filed on June 1st, and on July 1st, you get a letter from a debt collector. So, all collection activity must stop once the bankruptcy is filed. If you get a letter from a debt collector, get that to your attorney immediately. Even if it was a debt collector who wasn't necessarily notified of the bankruptcy, it still could be an actionable claim. So get that to your attorney, your bankruptcy attorney, and they will know what to do with it. But that could be worth something to you. So what I tell my clients is, once the bankruptcy is filed, any bills at all that you get, just bring them my way. We'll take a look at them.
Absolutely. Any correspondence before and after you file your bankruptcy, we want to see it. It could mean, that one letter could be $1,000 for you if it violates the Fair Debt Collection Practices Act. And certainly if it's something you receive after you file bankruptcy, you have rights under the law, and we want to help you protect them. John, we've kind of gone over the FDCPA and what to do if you feel like your rights have been violated. We've talked about the law. We now have some questions that are coming in from our viewers, and I want to give you a chance to answer some of those. Is that good with you?
Yeah, hopefully they're easy questions.
All right. So first question, we talked about this a little bit earlier, but what should I do if I'm being sued by a collector?
Oh, first thing, talk to counsel. Take that lawsuit paperwork, go meet with a bankruptcy attorney to review it. You want to review it for several reasons. One, that lawsuit paperwork, then they may already have a judgment, and the next step may be the garnishment order. And so you want to make sure that you get that paperwork to an attorney. The lawsuit paperwork may not mean a whole lot to non-attorneys, but to us attorneys, we'll be able to explain what it means, where you're at in the lawsuit process. Will your wages be garnished? Will your bank account be garnished anytime soon? That sort of thing. So that's the first thing I think people should do. The second thing is, once us attorneys get it, then we want to review that lawsuit paperwork to make sure that the collection attorney has complied with the FDCPA. There are certain rules regarding lawsuits. For example, they have to sue the individual in the jurisdiction in which the person resides. So the debt collector, if I'm in Indianapolis, the debt collector can't sue me in Chicago. They've got to come to Indianapolis and sue me. But I will tell you, on a regular basis, we file lawsuits against, typically it's debt buyers who have you, as you pointed out, Brad, they've bought some piece of information that's outdated. So my client gets sued in Johnson County when my client actually lives in Morgan County. And that by filing the lawsuit in the wrong venue or the wrong county, then my client has a lawsuit against that collection attorney or that debt buyer or both. And so we file several of those a year because it happens on a regular basis.
Great advice. I'd only add two things. Number one, act quickly. In Alabama, if you're served with a lawsuit in district court or small claims court, small dollar lawsuits that maybe just a few $1,000s, you only have 14 days to respond after you're served. So act quickly. Don't just push that aside. Consult with an attorney just as quickly as possible. And even though John and I both practice bankruptcy law, there may be some very good options outside of bankruptcy to deal with that lawsuit. As John said, they may have violated the Fair Debt Collection Practices Act, or maybe they can't prove the facts. They can't prove that you owe the debt. If they've bought that debt from somebody else, or perhaps it's been sold a couple of different times, they may have a very difficult time proving that you owe the debt. So a good bankruptcy attorney, and certainly that's the case in the Bradford Botes offices, and I know in John's office, we're going to talk to you about all your options. If there are options outside of bankruptcy, we're going to help you with that. But most importantly, as John said, sometimes these things have already gone too long, and you may be facing a garnishment or a lien against your property. We want to be able to help you. We don't want your wages garnished, especially right now when money's just so important. John, how, I'm getting these collection calls. They're even sending me text messages. What can I do to stop those collection calls?
So when the debt collector calls, simply tell them, don't call me anymore. Don't contact me anymore about this debt. And the debt collector must abide by that, except they can still sue you if they want. Or like I said before, retain counsel and make this your attorney's headache, not yours. And so those are the easy ways, the easy way out is, if you haven't retained counsel, tell them, don't call me ever again. And they're not supposed to. Too often they do, and then those become lawsuits as well.
But, again, great advice, but I'd emphasize what John said earlier. Keep good records. Sometimes the same collector will call you from various phone numbers, various representatives of the same debt collector. So it may be a different voice or a different name. A good attorney is going to be able to help you tie all those together. So keep good records, when the call came in, who it came from, all the detail you can write down and keep.
And now I think about this. I remember talking to a debt collector who's actually a friend of mine, and he used to collect for student loans in California, but his company would route their telephone calls through different parts of the country. So people never got calls from the same number or the same location. Sometimes he's routing his calls through Cleveland, sometimes Cincinnati. I don't know why it was always Ohio, but sometimes Columbus, Ohio. And so I agree. Take good notes. And the debt collectors are required to tell you who they are. They are required to give you a meaningful identification of who they are, what they're calling for, the amount due, and of course they can't lie to you. They cannot threaten individuals. We were talking about abusive tactics. A common abusive tactic that we hear about is the debt collector saying, well, if you're not going to pay this, I'm just going to garnish your wages. Like they can just pick up the phone, tell the court, garnish this person's wages. And that's simply not how it works. They have to go through the process of hiring an attorney, filing suit. They got to hope they get the judgment. And if they get the judgment, then they can start the garnishment process. But they make it sound like it's just something done with a snap of the fingers. And that's just not true. And those have become great lawsuits that we've been filing over the last several years as well, because it just happens so often. And I do believe that a lot of these debt collection agencies probably have good policies and procedures, but too often they're employees who who have a financial incentive in obtaining money because they usually get a cut of whatever they bring in. They usually will go out of bounds because they're desperate for money because they don't get paid a whole lot of money except in their bonuses. So they have this unfortunate financial incentive to stretch the truth sometimes. Or I was taking a deposition of an employee of a debt collection agency one time, and I asked her, I was like, so you have these policies and procedures, do you follow those? And she said, oh, not at all. Our managers tell us we can say whatever we want on the phone. Well, I got to tell you, that was an easy lawsuit. And that one paid out handsomely. But yeah, so unfortunately, I think, often the debt collectors will stretch the truth, and that gets in hot water.
It's an interesting question. Should I block collectors' phone numbers from my phone?
Oh, that is interesting. It depends on the client. If they want, they can. Or if they want to try to set up the, they want to see who's calling them, then don't block. I think it's just up to the individual client. As I said before, my advice to all my clients is, keep my card handy, and so that if you accidentally pick up the phone and it is a debt collector, then you can get out of that conversation by identifying me as your attorney.
John,
myself, I see a telephone number, it looks like a friend's number, or someone else that I know's number, and I pick up, and it turns out for me it's a solicitation. Somebody wants to sell me something, and then it's like, oh, another one of these solicitor calls.
I just to add to that, once you tell them that you've retained counsel, or once you just tell them not to call you anymore, I tell people you're paying for your cell phone, and they're so used to, not answering calls from a collection agency. You're paying for your phone. If a call's coming through and it's somebody that's not supposed to be calling you, pick it up and make a record of it. You have rights under the law. There's no need to block the number. There's no need to run from those collectors anymore. If they continue to call you after you've told them you're represented by counsel or not to contact you anymore, that collector is violating the law, and you have rights. And that collection activity is worth $1,000 to you. Plus, they have to pay your attorney.
I've got clients, to build on what you're saying. I've got a client right now that sends me screenshots of calls, and it's a married couple. They've made $4,000, and their bankruptcy hasn't been filed yet. Probably not going to be filed because they've got another 2 lawsuits against debt collectors that we're about to file. And all of their lawsuits have been based on these telephone calls. We sent out letters they've told the debt collectors, don't call me again. There's a few debt collectors I sent letters to saying, this is my client, don't call him. And then my client every Monday sends me screenshots. She puts it together over the weekend, and then he does as well. And they send me screenshots, and then those become lawsuits.
Sure. But no need to block them. Keep records of them. Send us the screenshot. Keep the recording if you have it. All of that information is helpful to us. This is a good one, and we hear it a lot, John. Is it legal for a debt collector to call my family members?
It is not. The only small area they could do that is for location purposes, but they're not calling family members to find out where you live. They've got all the information. They've done their skip tracing. They know more about you than what you ever imagined that they do. All these debt collectors use certain skip tracing databases to get information about you, such as they can get all your email addresses for the last 20 years, all your telephone numbers for the last 20 years, all your physical addresses for the last 20 years. They do asset checks on you. They do all kinds of background checks. And so they know a lot about you before this happens. And so, I'm sorry, I went off on tangent. What was the question again?
Whether or not they can contact family members or even friends about your debt.
So, they have no reason to be calling family, and that is a common lawsuit as well. And because these Skiptracing databases are so good, often they're calling neighbors. And I've had a number of lawsuits based on calling Joe Schmo that lives a couple of doors down. So they shouldn't be calling family members, but it happens too often.
You mentioned earlier the folks that you represent that plan on filing a bankruptcy at some point, but you've already gotten them several $1,000s and have another lawsuit or two pending. Good information for people to know, because people ask me all the time, how do your bankruptcy clients pay you if they're having financial issues? Well, often, if you have collectors that have been abusing you, we can get those collectors to pay for your bankruptcy, because we can get them to pay you $1,000 each time they've violated the provisions of the Fair Debt Collection Practices Act. All the more reason, if those collection calls are coming in, the stress, the anxiety that those will cause people right now, keep a good record, get to a good qualified attorney just as soon as possible. I want to do a quick recap. John and I are both bankruptcy attorneys. We're experienced bankruptcy attorneys. We take what we do seriously, but we also represent people that have been victimized by abusive debt collectors. My office, my firm, we have offices throughout Alabama, throughout Mississippi, and in the Knoxville area in Tennessee. You can reach us at the toll-free number that's on your screen now. It's 855-277-2245. We have representatives available to take your calls right now, talk to you about your situation, help you schedule an absolutely free initial consultation if you'd like, from the comfort of your own home or office. Be safe right now. If you're in Indiana, if you're in the Indianapolis area, John Steinkamp also helps people with bankruptcy issues and that have been victimized by abusive debt collectors. John's information is on our screen. John has said that he's also doing absolutely free initial consultations right now. I can vouch for John and his staff. They absolutely know what they're doing. They're well qualified, and they're not going to try to sell you on something. John's office is going to try to help you with the solution that is best for you. We want you to know we understand that people are hurting. We understand, because we've both done this for a long time, the problems that not being able to pay your bills can cause. We know what money problems can do to a family, what money problems can do to a marriage. You've got to be proactive right now. You've got to reach out and get help from somebody that's qualified. And we know it's humbling. We know it's hard to reach out to an attorney, but you owe it to your family. You owe it to your children if you have children. You owe it to the people you work with every day that you may be tense around right now. Be proactive. Reach out for help. If a collector is being abusive, we will help you, and it's not going to cost you any money. If a debt collector is violating the provisions of the Fair Debt Collection Practices Act, not only do they have to pay you, but they also have to pay your attorney's fee. And if you're represented by John's office or by one of our offices, we're going to make sure you're taken care of, and we're going to try to give you the peace of mind that we hope you saw in last week's podcast from Adam Webster. Adam went through a bankruptcy. It was a very tough time. He talked about how he put off making that call to a bankruptcy attorney, but once he finally did and got his discharge and his fresh start, his life just started over. On behalf of John Steinkamp and his staff, and on behalf of all of us at Bradford Botes, we want you to know that we're here to help. John, thank you so much for joining me today. Is there anything you'd like to say in closing, John?
Yeah, just real quick, I want to build on what you mentioned. I often tell my clients that, they come in and they've got the stack of bills with them, and they always say, I feel like I've been so irresponsible. And I tell them, look, it's not irresponsible to have debt. Life happens. Life throws you curveballs once in a while. But what is irresponsible is not doing anything about that debt. And especially if you have children and you've got to put food on the table for them. And burying your head like an ostrich is not any way, that's not going to help your kids, and that's not any way to approach your debt scenario. So the responsible thing is seeking professional help. If you have a health issue, you go to the doctor. If you have a debt issue, see one of us bankruptcy attorneys. That is the responsible way of handling this stuff. And then since we're wrapping things up, we've talked about life before bankruptcy and a little bit of fair debt work during bankruptcy. After bankruptcy, if you continue to get any bills, contact Brad or myself. I had a client that 4 years post bankruptcy showed up in my office with a bill from one of the debt buyers that we mentioned. And of course, it was the exact same debt that was included in his bankruptcy. 4 years later, he's getting a dunning letter again. So that was an easy lawsuit. And I got money from my client. We got to catch up. He's a great guy. And then also check your credit reports. Sometimes these debt collectors remain on the credit reports post bankruptcy. I see that on a regular basis, and those can be fun cases as well. And having a clean credit report is everybody's right after they file bankruptcy. It's part of that fresh start. And if you have a credit monitoring service and you think there's something wrong with your credit report, or if you get turned down, go see Brad or myself, and we can certainly help you with that as well.
John, I think you just underscored why it's not just important to talk to a bankruptcy attorney. It's important to talk to an experienced and qualified bankruptcy attorney. Unfortunately, there are a lot of people that are going to be having money problems in the months ahead of us. A lot of people that are having money problems now. And when that happens, there will be a lot of new businesses out there that will try to tell you that they can fix your financial problems. You want somebody that's going to pay attention to you, to your needs, that knows all of the options and is going to be there for the long run. That client that came to see John 4 years later was able to trust that he was going to be there. At Bradford Botes, we've been helping people with financial problems for over 30 years, and we're going to be here for another 30 years at least. So until next week, on behalf of John Steinkamp and his people, on behalf of us at Bradford Botes, God bless, and we're here if you need us. Thank you, John.
Thank you very much.